The first one is whether you have answered directly that you took the money or did not take the money. I think we need to get that out of the way. The implication of the allegation is that Mr. Katiso Molefe made 2.5 million rands available for the payment of a range of people, which could include the police, the prosecutors, and even the judge. And the big elephant is whether or not the judge took bribe money. Can you just answer that?
I did not take any money.
It is a week of reckoning for the South African judiciary. Gauteng Deputy Judge President Aubrey LEDWABA'S stands as the sole candidate for the post of Gauteng Judge President, but his path to the top is blocked by untested allegations leaking from the Madlanga Commission.
Prior to this bail, we had already received information from informers and sources to say Katiso Molefe will get bail. They went as far as giving the figures as to how much he's going to pay for his way. But now that information will be dealt with more by witness B. What I just wanted to highlight here is that at the back of our mind, when we went to the courtroom, we already knew that this is what has been said to us. And then we didn't know if it was going to transpire the way they said it or not. We also raised it with our commanders to say, this is the information that we received as a team to say, this man is going to get bail. And then this is how much he paid for his bail. I'm not paying now bail money. I'm saying paying the process of him to be giving bail against all odds, which then was talking to corruption.
There are several allegations that have been made against the judge, the acting judge president right now, which is Aubrey LEDWABA. And the allegations center on the bail application of Katiso Molefe, an alleged member of a powerful criminal cartel. In-camera testimony at the Madlanga Commission claims that Judge LEDWABA showed impartiality by being overly lenient towards Molefe, despite the state's evidence of his criminal links.
My main concerns in what the judge expressed there is to say if this would not be too restrictive. I felt like he was already showing the signs of lenient towards the accused, because the accused was the one applying, and he already placed on record what he's willing to take. But the judge is the one who feels it's too restrictive. I felt like the judge is having too much lenient towards the accused, and that's where I already knew that he was going to be granted bail already.
The JSC Objections Committee, chaired by Advocate Nhlanhla, must now decide, can a judge be promoted while these allegations remain untested at a separate commission?
There are several objections to your candidature. There are 6. We have considered all of them. We have dismissed the objection relating to St. James to Chantal Home. You would remember that?
Yes.
We have dismissed the objection from Senior Magistrate Singh. You will remember that?
Yes, I've noted that.
Yes, but we could not dismiss the objection from the Helen Suzman Foundation and the objection from Mr. Pitso Ramatsebe. Now, to start with the one from the Helen Suzman Foundation, we've decided that you must answer it openly in this forum.
LEDWABA has not been formally invited to Madlanga Commission, nor has he been cross-examined. He maintains his resume is untainted, but the Madlanga clouds hangs heavy over the Pretoria High Court. Before we can go any further, he was very much asked regarding this. As I've played, these are the objections that he received from Advocate Nhlanhla reading. And this is how he responded with regards to the bail situation that involves Katiso Molefe.
After that witness gave evidence at the Madlanga Commission, I was informed by the Chief Registrar that the Commission had requested a copy of the proceedings and a copy of my judgment. I can just mention in passing that before those documents were given to the Commission, I was not given an opportunity, or the Chief Registrar did not contact me to look as to whether there are any corrections that I needed to make on the proceedings. But I take that as being to my benefit, because if that was done, other people could have thought that maybe I could have changed some of the things that happened on record. Immediately after listening to the evidence of witness A, I instructed an attorney to write to the commission and to check with the commission as to why didn't they give me an opportunity or warn me that there will be evidence that would be given against me. And in the response, the commission stated that they will be preparing a report to the president in December, and they'll deal with that matter. I also need to mention that I did inform the commission that if nominated, I intend applying for a position of the Judge President of the Gauteng Division. And the response of the commission was that they'll ensure that I'm not prejudiced in any manner, and they will ensure that my matter is dealt with before the JSC sitting. That has not been done. The commission has not yet come back to me. What I can say about the allegations that were made against me is that the witness A indicated that witness B will corroborate or will give more information about his evidence that I could be involved in arranging that bail should be granted for Mr. Molefe. The commission further indicated to me that the reason why they did not inform me about the evidence of the witness is that they only had that evidence for the first time when the witness was testifying. And when I was busy with my preparations, I asked myself that if that evidence was only given for the first time at the commission, how did it come that one of the commissioners should tell the witness to mention the name of the judge that was involved in that? That aspect is neither here nor there. I can also mention that I dealt with the bail application of one Mr. Molefe. It was opposed by the state. And when the proceedings started, the state advocate did not ask for my recusal. I'm mentioning this aspect that he did not ask for my recusal because the witness stated that they informed their seniors and their prosecutor about what they heard from their informers. The proceedings went on. I granted the appellant or applicant bail. And what is most interesting that I need to state to this commission is that about a month or 2 months after Mr. Molefe was granted bail, he was arrested, and 4 additional charges of murder were added to his charges. The magistrate refused bail, and the matter went to there was an appeal to the High Court. I need to mention that I did not take any part in appointing a judge who was to hear that matter. The matter was heard in the Johannesburg local division, and I think the retired DJP allocated the judge to hear the matter. And in that appeal, the court again granted Mr. Molefe bail in the amount of 400,000. In the media, what was mainly published was that I granted bail to Mr. Molefe, but when the other court granted him bail, they did not make news in the media. Again, the witness A also mentioned in the social media that he instructed the prosecutor to appeal against my decision. The prosecutor told him that there were no prospects of success. And that is where the matter is. What I can say is that when I dealt with that bail application, I dealt with it in the normal course of my duties. I also want to mention that it was not the first bail application that I dealt with as a DJP. And this incident happened during recess. Usually, if there are bail appeals or urgent matters to be attended to, I would go to my office and check, and if there are no judges, I'll deal with the matters. And when this bail of Mr. Molefe was entertained, it was not the only matter that was on the roll. There was another bail application that I also entertained. Yeah, I think I can go up to that one.
Yes, that
As in the clip that I've played, it doesn't seem like he wanted to give a direct answer. But Mkhwanazi asked again, did he receive the 2.5 million bribe? And this is what the judge said.
some further questions that arise from these objections, if you don't mind. The first one is whether you have answered directly that you took the money or did not take the money. I think we need to get that out of the way. The implication of the allegation is that Mr. Katiso Molefe made 2.5 million rands available for the payment of a range of people, which could include the police, the prosecutors, and even the judge. And the big elephant is whether or not the judge took bribe money. Can you just answer that?
I did not take any money in respect of this bail application. I did not know Mr. Molefe at all. I've never met him. I dealt with this matter in the ordinary course of my duties. And why I dealt with that matter, all bail appeals are regarded as urgent. Hence, I'm saying there were 2 bail applications that needed attention during recess, and there was no judge who was available that I could allocate this matter to. And it was not the first time that I would deal with the bail application of applicants. Mention was also made about me being involved in the bail application of Mr. Nhlanhla, one of the accused in the SENZO MEYIWA case. Because there was no judge available and I realized that it is an urgent matter, I adjudicated on that matter and gave a ruling that Mr. Nhlanhla should not be granted bail.
Yes, the second thing that arises is why, as the DJP, you did a bail, because ordinarily those things are done by, I would say, puny judges.
Commissioner, as a DJP, my job is not only just to allocate matters to judges. And I also do other work. I also do trials. I also sit in special motions. I also do bail application, so that I should be aware of what is happening in my court, so that when my judges complain that they're overloaded with work, I should have tasted, I should have done that work. Because usually we would sit with the judges and just for example, they complain that they are receiving about 40 unopposed applications, that number should be reduced. And if, as a DJP, you've been in those courts, you've seen those documents, you appreciate what your judges are saying. And even in my stint as a DJP, there's a time where I also did urgent court, just to have a good feeling of what is happening in the court that I'm a leader as a DJP.
Obviously, the biggest issue was his errors in the reasoning, the rationale, the ratio decidendi of how he got to the decision that he got to. And this is what witness B told us with regards to the role that the judge played there in the bail application of Katiso Molefe, the material facts that he missed out on.
Count 2, possession of controlled drugs, cannabis. Count 3, possession of prohibited weapon, self-loading smooth bore gun. And count 4, possession of prohibited weapon, self-loading smooth bore gun. Witness B, can you confirm?
Yes, I confirm, Commissioners.
And do you have a comment on this paragraph?
No, I don't have. Yes, I can confirm this paragraph, and I still see another dishonest from the accused because he misrepresented himself in UK and using a totally different identity that is not his. And the question is, shouldn't he be arrested at that time with this kind of identity?
In one of the exchanges related to the conditions related to Mr. Molefe's movement, Mr. Molefe's lawyer asked for movement within the Gauteng province or even house arrest. The judge of his own accord inquired whether that would not be too restrictive, as Mr. Molefe had businesses in other provinces. Mr. Molefe's lawyer responded that she does a number of these matters where there are business-related reasons for travel. These would be communicated and written permission of the investigating officer would be sought, which cannot unreasonably unlawfully be withheld. The judge then raised the issue of the child and girlfriend who live in KZN, to which Mr. Molefe's lawyer responded that they can travel. Despite Mr. Molefe's lawyer's acceptance of this well-established condition, the judge made a comment that bail should not be a punishment. In the end, the bail condition granted was basically that Mr. Molefe can leave after informing the IO, and the IO should not object unless there is a valid reason. Witness B, can you confirm this paragraph?
Yes, Commissioners, I can confirm this one. And maybe to have some comments on this one. My main concerns in what the judge expressed there is to say if this would not be too restrictive. I felt like he was already showing the signs of lenient towards the accused, because the accused was the one applying, and he already placed on record what he's willing to take. But the judge is the one who feels it's too restrictive. I felt like the judge is having too much lenient towards the accused, and that's where I already knew that he was going to be granted bail already.
Third question that arises out of this is that your judgment was a poor judgment. It did not engage with the correct principles because the nature of the offense placed the onus on the accused, and the reasons that you gave were poorly motivated. And this is being said in the context that this was an entire scheme arranged by Mr. Molefe to pay his way out of prison.
Commissioner, I deny that the judgment was a poor judgment. I gave reasons why I thought that there were exceptional circumstances justifying that bail should be granted. In some of the issues that I raised with the prosecutor considered that there were material misdirections on the part of the magistrate. I can think of one part in the judgment of the magistrate where the magistrate said, I'm not going to grant you bail because you cannot afford the amount of bail. And I also mentioned in my judgment that that was a misdirection because if an applicant wants bail, the relatives, other people can pay bail for him. The other misdirection that I mentioned in the judgment was that the magistrate said much as the applicant testified or made an affidavit that he had a house worth about 17 million, the applicant was supposed to have produced a title deed. And that evidence of the applicant that he's got a property worth about 17 or 14 million was not disputed. The other aspect that was raised by the magistrate that is in my judgment was that the applicant was supposed to have produced his salary advice showing how much money was he making a month. And that is an allegation that was not disputed by the state when this bail application was entertained. So I fail to understand on what basis. Is it alleged that my judgment was a poor judgment? And as I've mentioned earlier, that witness in particular told the prosecutor that they should appeal against the decision. There was no appeal. And I can also mention that when my other colleague gave bail to the same gentleman, as far as I know, there was no appeal lodged against the judgment of my other colleague.
Obviously, Julius Malema these days comes across as a person who, I don't know, it depends on how you see it. One can say that he's just being neutral and not finding someone guilty before they are actually guilty. But that's the thing. His questions to this person suggest to me that he's mocking this whole situation. He is making it a joke to say that we've all been accused of things. We know that he's also been mentioned at the Madlanga Commission. But the way he's also trying to exonerate Mr. Andrew, it's just so worrying. That's why I'm saying that, hey guys, this panel, so funny. He asked him with regards to this bribe that was served or was alleged that he received. That's the thing. If you guys can listen to this interview of Judge LEDWABA, he's too vague throughout. Even with this answer, guys, if you didn't receive a bribe, it's a yes or no. You can even tell them, subpoena my banking documents. You can even do an audit on my life, my lifestyle as part of a addition to this interview so that you can be satisfied that I am not involved in any of those things about cartels and all of those. You can investigate. Guys, if Madlanga can investigate Mkhwanazi, Commissioner Mkhwanazi, and find out that he lied about a funeral, about his parents, don't tell me that the JSC is going to fail to do the same thing. They should just do a lifestyle audit on this guy. It's as simple as that. Just taking what he's saying, especially since he's giving vague answers, he's refusing to answer questions directly. For me, I think it's a red flag. Where there's smoke, there is fire. Trust me on this one.
I mentioned that when my attorneys wrote to the commission, we informed the commission that if they need a response, I'm more than willing to make an affidavit, and much as all the issues relating to judges should be reported to the JSC, but we indicated their willingness to assist the commission as far as this issue is concerned.
Yes, so as you are sitting there, there is no letter that says you must appear before Madlanga Commission on such a date, or you must appear before a Judicial Conduct Committee on a date of so and so based on this allegation.
That is correct, Commissioner.
Now, the witness A, if it's witness A, says he's got 12.5 million to be given to a judge and prosecutors. Has he made any effort to contact you to come and give you your portion of 12.5 million?
I've not been contacted because I don't deserve any portion of that.
Yes. So, but does it specifically say you or a certain portion must go to a judge?
The witness testified that he is not sure as to where would this money go. And as I've indicated, how my name came out in that commission is still a surprise for me.
Yes, so there was never an allegation that 12,000 will go to prosecutor, I mean half of 12,000 will go to prosecutor Malema, and then the remaining portion will go to Judge LEDWABA.
There's no such an allegation, Commissioner.
And then is there any rule that says as a JP or acting JP, there are certain matters you can't hear, including bail?
There's no such a rule.
Thank you.
Nice thing, not everybody is buying this story of LEDWABA, because look at this panel, this candidate, or these questions that come from this particular commissioner. Amazing. He challenged him. He went into the core of it, and it didn't disappoint us. And I think all of us, we thought Malema is going to be like this, but it became the other way around. But you know, we can't expect much from Julius Malema. He's in trouble. Tomorrow he's facing the courts, so you don't want to be upsetting colleagues of the colleagues, because you don't know what might happen.
Commissioner, those unsubstantiated allegations, in my view, they cannot be regarded as being serious. I've also mentioned that there's a criminal case that has been opened at Boschkop. But when you look at what is said, it's just an allegation that these charges received money. Nothing substantiating it. And because there's no substantiation, I take them not to be serious.
But then why did you want to respond to them? If they were not serious, why did you want to respond to them at the Madlanga Commission?
I wanted to respond to them because my name was mentioned. And I also indicated in the letter that we wrote to the commission that if these allegations are serious, the matter should be reported to the relevant body.
The Office of the Chief Justice issued a media statement acknowledging that the testimony or the allegations are unsubstantiated, but they've got the potential to damage the integrity of the judiciary. Do you accept that?
Yes, I do accept they've got that potential, but in deciding how to deal with those allegations, one also needs to look at the integrity of the judiciary, and hence I've said these are difficult things that are there. I made it a point that I consult with senior judges and other retired judges to get their view on it.
Yes, and that's an issue for me. The Office of Chief Justice suggests to you that you consider taking special leave. You don't. You decline. And then you go and solicit advice from retired judges. Between the Chief Justice and the retired judges, who is the custodian of the integrity of the judiciary?
So obviously it's the Chief Justice who's the head of the judiciary.
And then why did you choose to ignore the suggestion and advice coming from her? She was not saying that you are guilty.
Yes.
She was not saying that you took the money. She was only saying that it will be in the best interest of the judiciary if you take this course of action.
I think the candidate has answered this question, Commissioner Mangena.
But that's the thing. This guy is also saying that whatever that is said at the Madlanga Commission is just hearsay. Witness A spoke about hearsay. But that's the thing. It's like none of these commissioners actually listened to the Madlanga Commission testimony. Witness B gave the details of that. Yes, there is no confirmation or evidence that there's actually someone who went and gave him the money and they actually saw that person giving LEDWABA the money. But the fact that these allegations are made, investigations are supposed to be conducted. Instead, what I see here is about MALEMA and some of these commissioners making a joke out of this. And it's just saying that, it just so happened, and these are just allegations. As he said, this is just a hearsay, nothing deep of this particular situation.
Did you think about it? I thought about it. And hence, I said I consulted with senior judges, retired judges, on the facts presented, the hearsay evidence presented. It would not be in the interest of justice that the Gauteng division should not have a leader. There are cases that have been mentioned against judges, and looking at the facts of those cases, the information available, some of them are on special leave because of the seriousness thereof. But as far as this case or these allegations are made against me, looking at the fact that there is no appeal in the matter, looking at the fact that my other colleague dealt with the bail, and it's interesting that in the media, it's only my name that is mentioned. There has not been anything that I've heard from the public that the judges of the Gauteng division, they're involved in some shenanigans as far as the bills are concerned. So to answer you, Commissioner, on the information that is available, the hearsay, I don't think it's in the interest of justice that we should wait for the matter to be finalized. And again, as I've said, the Commission made an undertaking that they will ensure that there's no prejudice to protect the integrity of the judiciary. They'll deal with this matter, and I haven't had anything from them on this issue against me.
Obviously, he was asked about the issue of Paul O'Sullivan because it's one of the very burning questions in this commission with regards to the 48-hour notice. And he said that it's not him. And yeah, let me just play how he responded to that question of Paul O'Sullivan.
And my last question is, you mentioned it and the Chief Justice said that it had been responded to, but I'd like to hear your response around the special 48-hour dispensation that was granted to Mr. O'Sullivan.
Commissioner, I was not involved in that matter. It's unfortunate that when that order was mentioned, my name was raised and said I made that order. There's a media statement that has been made to clarify that I was not involved in that order. That order was made by another judge. So as to why the judge made that order is done, and I cannot reverse that. But this also shows that we need to be very careful that our judiciary should not be unnecessarily tarnished. Because some of the things, if media statements are not made, what will hang in the heads of the people is that LEDWABA gave Mr. O'Sullivan a special dispensation that before he's arrested, he should be given notice. I was not involved in that matter at all. And the name of the judge that was involved has been made public.
A follow-up question, was it a judge in your division?
Yes, was acting in my division, the judge.
And what has been done about that judgment?
The judgment was made in 2019. That order was made in 2019. And nobody challenged that order. So there's nothing that I can do. The order is there, it's valid until it is challenged.
He therefore addressed the allegations that were made by Advocate TEFFO, as well as things that are relating to the SENZO MEYIWA case, the bail applications of Mkhwanazi. Specifically with the issue of TEFFO was the issues of bribes and all of those things. So this is what he responded with regards to those allegations.
Just to mention something again, it was in the media that there's a case, criminal case against myself, the DCJ and Judge Mkhwanazi, CAS 130/2/2026, wherein one Mr. TEFFO made an affidavit and alleged that the three of us have received an amount of 35 million. Now, if we are going to wait for this matter to be investigated before other important positions can be filled, I don't think it's in the best interest of the judiciary. I can also mention that there was summons issued against me for an amount of 50 million by one attorney, Mr. Tobani, alleging that by refusing to grant bail to Mr. Nhlanhla, his client instructed him to withdraw as attorney of record, and now he thinks that he's lost some income because of my decision. To sum it up, if there is an allegation against the judge, the Chief Justice and even the former Chief Justice has made it clear that if there is anything that needs to be made against the judge, it should be reported to the JSC. And these matters that I've mentioned have not been reported to the JSC. I can also just mention again that if one is faced with allegations of this nature which affect the judiciary, some of the decisions are not decisions that are easy to make. And whatever decision I make to apply and the decision to continue with my work and not take the special leave were based on, I consulted, I discussed the matter, some senior retired judges. If their names are requested, I'm willing to do that. But they also told me that before you take a decision to take special leave or before you decide whether you should step aside, in quotes, one should look at the seriousness of the said allegations against you. And in that discussion, they were also of the view that with what has been presented, the hearsay evidence of witness A, and what is published, the judiciary would be crippled if always there are allegations and that a judge should step aside.
Yes, so you're saying the allegations are serious, but there's no evidence to support them.
You know, the way they've been presented, I hesitate to say that they are serious because that is just pure hearsay. And if these allegations were serious, if we look at the evidence of witness A, he stated that he informed his superiors about this plan. And I think that there were other steps that they could have taken to ensure whether these allegations carry any weight or not.
Now let us move to another question, the objection that came with the allocation of the Pentecostal Church case to Judge PHAHLANE. Judge PHAHLANE is the one that is currently going through a court case because she was in a way bribed by this leader of the Pentecostal Church. While LEDWABA fights for promotion, Judge Portia PHAHLANE is fighting for freedom. In March 2026, her corruption case was postponed for further investigation. that now involve her fellow judge. Counts of corruption. The state alleges that PHAHLANE accepted bribes to influence the legal battle over the succession of the International Pentecostal Holiness. It was Aubrey LEDWABA himself, as acting judge president, who laid the initial complaint against Judge PHAHLANE with the JSC. Prosecutor William Van Zyl revealed that new information has resurfaced connecting the judge to a broader network of judicial capture. And this is what was said by the Judge LEDWABA in relations to these allegations of Judge PHAHLANE.
My response is this. I remember when this issue surfaced, I had a meeting with Judge PHAHLANE and the DCJ about this issue of recusal. And by then, she had not yet made a decision as to whether she's going to recuse herself or not. And we told her that we are waiting for the judgment, and we could not tell her which way she should go. And in that meeting again, because the parties agreed that she can deal with the matter, it did not cross my mind that I should tell her not to continue with the case.
Judge PHAHLANE remains on special leave, barred from her own court. The Judicial Conduct Committee has given her a mid-April to explain why she shouldn't face a tribunal that could lead to her impeachment.
Thank you. Then the last topic is it's the allocation of the case management responsibilities and trial responsibilities in the International Pentecostal Holiness Church case to Judge Portia PHAHLANE, who has since been charged for corruption and bribery. The concern is that the judge seems to have had a prior existing relationship with the people that are alleged to have bribed her before she was allocated the case management and the trial duties. The question then that arises is, given that you are the person who did the case management allocation and the trial allocation, how did this happen? The suspicion being that she knew beforehand that she would be allocated this job, and that's why she started taking money from the alleged corruptors. Can you take us through from your perspective?
The practice in the Gauteng division in respect of case management is that the parties would request that I should allocate a matter for judicial case management. And I would look at the list of the judges, take into consideration if I have allocated them any commercial matters or not, if I've allocated them bail applications or not. And if I realize that the judge to whom I will allocate the matter for judicial case management is available, that matter will be allocated to the said judge. This matter was initially allocated to Judge Potterell. It was in 2020. He managed the matter. He dealt with other issues, like the parties wanted the matters to be consolidated. Actually, when I looked at this matter, there were three main cases. The other case involved money that was freezed, money of the church, and the Judge Potterell partly dealt with that aspect. And in 2022, according to the records that I have, the parties wrote to me. Usually when they write to me, they also copy their opponents, requesting a judicial case management. And I allocated this matter to Judge PHAHLANE. And the practice is also that if a matter has been allocated to a judge, the judge will not hear the trial because the judge has been involved in the matter, unless if both parties agree that the judge should deal with that matter. And as far as this matter is concerned, I think Judge PHAHLANE started managing this matter in about 2022. During the management proceedings, both parties agreed that she should continue with the trial. This issue that Judge PHAHLANE was not supposed to deal with the trial, in my view, there's no merit in it because the parties would have objected. This matter was set down for 3 weeks. And if there was anything untoward that the judge should hear the matter, they could have raised it. Interestingly, on the first day of the hearing, there was an application brought for the recusal of Judge PHAHLANE. And that recusal application was based on the fact that there are allegations that she has been bribed. Judge PHAHLANE dealt with that application and dismissed it. And there was a second application for recusal. She also dealt with it and dismissed it. Judge PHAHLANE also alleges that she was threatened when she was dealing with this trial. She approached my office, told me about the threats against her, and I advised her to open a criminal case and to talk to the court manager so that an assessment could be made whether she was in danger or not. She further told me that the court manager did nothing about this, and she decided to organize her own private security. I can mention that I was concerned about the fact that a colleague is in danger and she's not assisted. She further told me that this matter was reported to Mr. Naidu at the Office of the Chief Justice to check if indeed she was in danger or not. Because it was disturbing that there would be private securities in the court building armed. I raised this with her, but she continued to engage those private securities. So much as I've also raised other things, but there's nothing untoward that Judge PHAHLANE dealt with the trial because the parties did not object to it. Actually, the parties agreed that she should deal with the trial.
Thank you, TJP. So as I understand, you did not allocate her the trial. You allocated her the case management, and then the trial was as a consequence of an agreement with the parties.
Yes, I allocated case management, and while she was busy case managing this matter, they agreed that the duration would be about 15 days. Judge PHAHLANE informed my office and the office of the judge president so that we could make, when we do the duty roster, we should know that she'll be doing that matter for 15 days.
But not for permission, just to inform you.
Yes.
I'm not going to lie, I was kind of moved by the way some of the members of the panel who are the commissioners in this interview, they came across as people that are already defending him, saying that whatever decision he took regarding Katiso Molefe, it's in line with criminal law. And there was nothing wrong he did. And I think to me that became one of the red flags that told me that since he's the only candidate, high chances he might end up getting the post.
Or there was a suspicion that something might have happened.
Yes.
But that matter, when you dealt with that matter, you were dealing with it not as a court of first instance, but it was an appeal against the magistrate decision to refuse to grant bail. Is that correct?
That's correct, DP.
And you dealt with it in accordance with the established principles of criminal procedure relating to the grant of bail. Is that correct?
That's correct, DP.
The South African judiciary is facing its greater test of integrity, whether it is an acting judge president seeking promotion amidst cartel allegations or a high court judge facing bribery charges. The message from 2026 is clear. No one, not even those in robes, is above the forensic gaze of the commission. I just feel like his excuses of saying that he's not yet been invited at the Madlanga Commission, I'm speaking about LEDWABA, it does not suffice. They were supposed to halt this whole thing. Or probably the JSC was supposed to write to the Madlanga Commission to expedite the appearance of Judge LEDWABA. And what if he gets to be appointed right now, guys? You see the unfairness of these processes. I just feel like this is unfair, but as we are watching these interviews, we're going to see what is going to happen, what the JSC is going to decide on. But as where I'm standing right now, I just think that it's so unfair that the JSC is continuing with interviews amidst these allegations, and his excuse is that he wrote to the Madlanga Commission and they said that they're going to call him and that he's going to appear before the interviews. Unfortunately, the interviews have happened. Madlanga has a lot of work. If there's people right now that are accused of bribing people in the commission so that they can expedite their appearances, that should tell you that the commission has a lot of work. It has a lot of people that have to appear, and they have to move with a certain sequence because they have a structure that they have to adhere to. They can't just break that structure because LEDWABA wants to be the judge president. And what is so annoying is his reason why he thinks they should not wait for the Madlanga Commission. He's speaking about the interest of justice and the interest of the country. Aibo, when you received the bribe, did you think about the interest of the country?
The last question on this topic is from HSF, who say that your candidature should await the outcome of the Madlanga Commission. Any response?
Commissioner, my response to that is that this application is not about me. I'm looking at what is in the best interest of the Gauteng division. I think the division needs a leader.
I'm not going to lie, I wouldn't be shocked if he actually gets this position. We heard even from Lieutenant General Mkhwanazi how our justice system is so flawed in his last appearance at the ad hoc committee.
No, I don't remember. I think it's because it has not been interrogated as much. In a court process, you will have a complainant and the prosecutor and the accused on the other side with his lawyers, and there's going to be questioning that are done, systematic in that fashion. There are questions that I would have wanted to ask that might uncover things, but I'm not in a position to do that. And I don't have a representative in terms of prosecutor to be able to do that. That's why I couldn't probe some of those things. But for your information, honorable members, some of the things that are happening in our country, which I know of a person involved in drugs, a person who's working with us and giving us information, is that one individual is arrested for a crime, is released, is arrested, is convicted, and he makes an appeal and is released on bail pending the appeal, and is told by the prosecution that if you have X amount of money, you can pay for the magistrate to completely remove this case. Otherwise, if you don't have money, stay out of trouble. Otherwise, we will not call you back to court. The person is out pending an appeal. There are thousands of them that are released like that, and they never get invited again to come back to court. So this is a person who's close to Nhlanhla, who's released like that.
So how would
so it's a collusion that we get between the police officials, the prosecution, and some of the presiding officers. And this is across the board. But in this case of these drug investigations that were happening, there are only a few presiding officers that were picked up that participated in enabling this thing to happen.
So how would you guide us in terms of us doing, or as we are about to conclude our investigations in that regard into the judiciary? Because we haven't touched heavily on that at all.
I will say maybe we need to sit down with the Chief Justice or the judges themselves. And I'm glad we have judges like Madlanga that is no longer part of that system, who's outside, who's busy with these things. You must sit down with them and be able to come up with Judge Zondo, who was probing some of these things. Sit down with them and be able to see how can we then be able to protect the citizen from the involvement of these presiding officers. Honorable members, when we have the powers given to a presiding officer, although the members will argue, the SC will argue, but when the presiding officer is given powers to grant bail, and one presiding officer says, I'm not giving you bail because you were convicted in a foreign country after you misrepresented yourself. You were convicted for a crime of drugs. You misrepresented yourself by giving a false particulars. You left the country illegally for that matter. He was convicted. So which means you are a flight risk. You've proven that you have left South Africa to go to another country in the first instance. I'm not granting you bail. The cases you are facing are serious cases of murder and the likes. So I'm not granting a bail. But this person then goes into the higher court. And the higher court grants bail regardless of those conditions. Regardless of those conditions. And it still says, you're free. So a person is given bail of 100,000 rand. He gets arrested again. While he's arrested for triple murder this time around. The first one was mad, now it's triple mad, is taken to court. Another judge comes and say, yeah, well, yes, you're on bail, but we're happy with you outside. Let's make it look like it's a serious bail. Then they add 400,000 rand. This person is on R500,000 bail for murder of 5 people. How many must he kill before the judicial realize that he deserves to be behind bars? There are people that are rotting in prison that have not killed anyone. They were arrested for an assault, a theft, but they are denied bail and in prison. But the person who was murdered, accused of murdering 5 people and more, and drugs on top of that, but is out on bail. So you begin to wonder. So when you wonder, then you start probing more. That's why I'm talking about recordings that end up being made, that end up saying, okay, well, this is done in this fashion, this is done in that fashion.
I'm just so disappointed that this is happening, but I think as South African, we should brace ourselves and be ready that this man might be appointed as the next judge president of the Gauteng High Court, which is the Johannesburg division. I'm not going to lie, guys. I think that is definitely very, very highly probable. And I'm one of the people that are just going to be shattered by this whole thing if it does get to happen, because he didn't even answer. His answers were just too long, but they were not even getting to the straight point that we are trying to understand. He was supposed to come with a judgment and read the judgment, but the Madlanga has the judgment. By the time they call him there, he would have been the judge president. But let us just have faith in our JSC and have faith with Abongoga Itobi and the CIC and many other members of parliament and members of the judiciary that have been appointed to be part of the JSC. But yeah, I'm just watching these interviews. I'll give you guys another sum up when these interviews are finished as to how was his overall interview with the JSC, the questions that he's faced, and whether the probabilities of him being the judge president are high or low. Nonetheless, let me hear your thoughts, guys. I will see you on my next upload. Bye.